Good afternoon, everyone. I'm Mike Mangelson, Principal Counsel and Director for China IP in the Office of Policy and International Affairs at USPTO. I'd like to welcome everyone to our quarterly update on China IP legislation and case law. I'm joined by 5 of my colleagues on the USPTO's China IP team. Our China team is a dedicated group of China IP experts with 11 US-based IP lawyers, 3 IP attachés in our 3 offices in Beijing, Guangzhou, and Shanghai. And also we have our 5 China-based IP lawyers. All of our lawyers are experts in China IP law, as well as US IP law. And our 5 China-based lawyers are locally trained attorneys that specialize in specific areas of China IP law. Our mission is to help improve IP protections and enforcement for US companies doing business in and with China. We do this in a number of ways, including by consulting and working directly with individual US businesses on their IP issues in China. We also engage with our counterparts in China to secure reforms and improve the IP environment there. And we also secure high IP standards and trade agreements in China IP laws. We also provide extensive training programs and webinars such as this one to educate a full range of US companies doing business in China. Many of our programs focus on providing practical information to small and medium-sized companies and new-to-market exporters. Today's event is going to be part of our ongoing series of quarterly updates that we launched a year ago. The goal of these 1-hour updates is to help you and really to help us as well keep track of the many, over 60, I think, legislative and judicial changes that China has made over the past couple of years, partly in connection with implementation of its IP commitments in the Phase 1 US-China trade agreement. Our China team coordinates US government comments on these measures. And we're also holding technical calls and other communications with China to improve these measures. For example, earlier this month, we held a call with China to discuss measures on trade secret protections and administrative licensing, bad faith trademarks, patent term extension, and geographical indications. The key to any significant improvement in China's IP landscape depends on how these new measures are implemented at the local levels. Recent court cases, including those discussed today, provide some insight into this implementation. IP protection remains a top concern for US companies doing business in China. 78% of respondents in this month's AmCham China Business Climate Survey reported that they would only consider increasing investment in local operations if China improved policies to ensure greater protection of intellectual property. This is important for many US companies in China because they believe that innovation and R&D are the key to future growth there. Today's event will highlight the changes since our last update in December of last year. So first off, just a couple of housekeeping items before we start. As with all of our webinars, we ask that you please ask your questions through the email address askchinaip@uspto.gov. You'll also be receiving a survey after today's program, and I encourage you to complete that short survey, which will help us better understand your needs and improve our programming. Also, please be on the lookout for upcoming webinars, including one on IP licensing in China, and we'll be holding our next quarterly update in June. You'll find information about our programs on our China IP website at uspto.gov. And please take a look at the other resources on our website, including our China IP Toolkit, which contains a wealth of practical information, including best practices on protecting and enforcing IP in China. So now on to the program. Our program today will follow a moderated discussion format. I'll serve as the moderator. Our panel of experts include our copyright expert, Neil Graham, our trade secret expert, Mike Deal, our patent expert, Larry Lian, our trademark expert, Susan Anthony, and our IP enforcement expert, David Foley. So I'm going to start the discussion today with a discussion of copyrights with Neil Graham. Neil, I understand that China recently joined the Marrakesh Treaty. Can you tell us more about that treaty for those who may not be familiar with it?
Yes, thanks, Mike. China deposited its instrument of ratification with the World Intellectual Property Organization, or WIPO, on February 5th. and the treaty will come into force for China on May 5th of this year. The Marrakesh Treaty was signed by WIPO member states in 2013 in Marrakesh, Morocco, obviously. It requires countries that join the treaty to amend their copyright laws to more easily allow for the creation and the sharing across borders of audio and electronic Braille versions of published works, including Braille music, for people who are blind, have impaired vision, or any disability that prevents their use of printed media. Why was the treaty needed? The treaty addressed the problem that the copyright laws of many countries, such as the United States, would not allow the import or export of books that have been translated into Braille or another special format to or from other countries, because those cross-border activities would be considered copyright infringement. The result was what was called a book famine for the reading disabled around the world, because accessible format books could not be exported or imported between countries. The Marrakesh Treaty is designed to break down these barriers between countries. China's ratification means that Chinese-speaking people outside of China who are blind or otherwise impaired will benefit from greater access to China's rich literary traditions. It also means that the blind and visually impaired who live in China, and that's a population estimated to be about 17 million, will have easier access to Chinese language versions of books produced in other countries. So that's the kind of long and short of that issue.
Thanks, Neil. That was helpful. Was there anything unusual about China's accession to this treaty?
Yes, there was. China did not implement the import-export obligations of the treaty into its domestic law before it deposited its paperwork with WIPO. Ordinarily, a country that ratifies a treaty will first implement all of the obligations in its domestic law before it submits its instrument to WIPO. And China has always done this. In this case, however, China implemented some of the obligations in its recent copyright law amendments, but not the import-export obligations. So China's implementation is in many ways kind of a half-built bridge. We can only assume that China will address the remaining obligations and finish the other half of the bridge in the near future.
Thanks, Neil. Why don't we move on to protections for software? I understand that China recently issued its first algorithm recommendation case. What was the issue in this case, and what was the court's ruling?
Yes, this was a very interesting case. Recently, the Hainan District People's Court in Beijing issued a decision that addressed the question whether an online video platform that makes recommendation to users based on artificial intelligence technology should be held liable for posting infringing videos uploaded by users. So that may sound a little intimidating, but we're probably all familiar with recommendation technology if we subscribe to, say, Netflix or Amazon Prime or use YouTube, because all of these platforms make recommendations to users based on their previous viewing habits. This is what is now called push technology. The facts were these. The plaintiff, and you'll pardon my pronunciation here, was IQIYI, that's spelled IQIYI. The plaintiff was the operator of an online video platform. It paid a large fee to obtain the exclusive rights to broadcast the popular TV drama called Yangtze Raiders, which told about struggles for power during the Qing Dynasty in the 17th century. The series was very popular in China and viewed over 15 billion times over a period of 43 days. During the broadcast, another company called Byte, B-Y-T-E, used its recommendation technology to intercept the broadcast, and it posted a short video of the TV drama that had actually been uploaded by a user. So IQIYI sent multiple cease and desist letters to Byte, which were ignored, and eventually sued for copyright infringement. Byte argued that it wasn't liable because it was the user that who had uploaded the short videos, and Byte only provided a web hosting service and should therefore not be liable under the safe harbor provisions of Chinese law. The court nevertheless rejected that argument and found Byte secondarily liable for the infringement. It concluded that Byte had provided assistance to the users and should therefore bear liability because it contributed to the infringement when it knew or had reasonable grounds to know that its users had committed infringement that was obvious. The court said that even though Byte was a web hosting service, it had a higher duty of care because it made recommendations to users. I could say more, but I know we have a lot of other topics to go through, but that's the basic summary of the case. Very good pro-IP case from China.
Yeah, interesting. Quickly, do you think the U.S. court would have reached the same result?
Yeah, that's a very interesting question. Viewers may know that the Copyright issued a blockbuster report in 2020 on Section 512 of our law, which is the one that defines the roles and responsibilities of ISPs, Internet Service Providers. And the report explicitly noted that U.S. courts had interpreted our own safe harbor for web hosting, 512C, to cover video hosting services that use algorithms to identify and recommend videos. And these courts in the Second and Ninth Circuit have reasoned that these types of recommendation services qualify for the Section 512C safe harbor because their activities are related to the activity of storing user uploaded content. But after reviewing these cases, the Copyright Office concluded that it was unconvinced that Congress intended to protect any additional services related to the storage of content beyond the act of storage or providing access to the content. In other words, the Chinese court reached the same position as our Copyright Office did in its 512 report, even if US courts have yet to fully embrace that position. I think this shows that Chinese and US policies can sometimes show a remarkable degree of convergence.
Thanks, Neil. We'll get back to you in a little bit, but I wanted to go on to patents and Larry. Larry, last year, China's National Intellectual Property Association, CNIPA, made a series of announcements and plans to crack down on abnormal patent applications. What are abnormal patent applications, and do you have any updates on this initiative?
Yeah, sure. The term certainly is probably quite foreign to a lot of the people in the US because it doesn't quite exist in the US. You will see CNIPA and other Chinese agencies generally refer to abnormal patent applications as a patent applications filed not for the purpose of protecting invention or protecting innovation. It's kind of a not very helpful definition in the negative. I think it's fair to say, I mean, you will never hear CNIPA say this in the public, but it's fair to say it's pretty much essentially applications filed for the sole purpose of getting a subsidy or meeting certain rigid quantitative matrices, like how many patents to achieve certain status, like model enterprise with more than 10,000 applications filed per year, or some kind of reward. And there are certain kind of interesting details that you may have seen. I will not get into detail, but even the HUCO, the citizenship registration, could be helped. That kind of application could be helped with certain with patent applications, like high school students graduating, entering to college, or even a prisoner getting out of prison. There are all kinds of interesting stories which are all true, but it's the main thing is just rigid quantitative matrices and actually primarily the subsidy monies. And in terms of numbers, there is an update actually this year on January 6th, all heads meetings of IP offices in Beijing, the CNIPA commissioner provided the latest on the number of abnormal applications identified. If you recall, they did it starting last year in March, kind of in batches, I think 3 or 4 batches. I forgot the exact number, with the first batch like 300, 400,000 or something. But this year, the final full year number from last year, 815,000 applications are identified being abnormal. I did a rough calculation. That's like 15% of the total applications, around 4 or 5 million applications per year. That's quite a lot, and the withdrawal rate is actually quite high. The withdrawal rate, I mean by that I mean applicants, once they're notified, hey, your application is abnormal, they without disputing it, they just withdraw. That rate is actually 97%, indicating that a lot of these are probably really abnormal applications.
Yeah. Thanks. Are there any new measures to deter these applicants who file abnormal patent applications?
Yeah, yes, there is. The previous measures last year, I think I have not seen any cases threaten even criminal sanction with the patent agents, the patent lawyers. The CIPA required the All China Patent Agents Association, kind of equivalent or AIPLA, to self-discipline. And this year, the new announcement is a specific tying of filing abnormal applications being an act of dishonesty that's going to hurt your IP credit. If you're familiar, China has this social credit system that punishes a number of dishonest conduct. This new measure, I believe, announced in January by CIPA regulation on administration of IP credit of CIPA. Listing acts, one of the 6 is specifically filing an abnormal application. And another kind of potentially complex issue, but I'm going to try to make it simple. Let me digress a little bit. That I saw interestingly, the second act of that 6th act mentioned concealment of important facts. I thought that's quite interesting because the concealment of prior art, in other words, hiding prior art from examiners, I believe is a primary source of this kind of abnormal application filing. Normally, they just take some prior art, make some very insignificant changes, and file it as their own. But I have never seen concealment of prior art or hiding prior art written in Chinese law as an act being punishable. And this concealment of important facts, I think it's a welcome step, although it's not quite the same as concealment of prior art, but it's nonetheless a welcome step.
Thanks, Larry. So related to this topic, CNIPA last year also announced an initiative to reduce or eliminate patent filing subsidies. And this these announcements came shortly after our report that we published on non-market factors affecting IP filings. And you can find that report, by the way, for the audience on our website. Larry, can you tell us what the latest developments on this CNIPA initiative are?
Sure. The report, by the way, as Mike mentioned, that measure reducing subsidies, I believe it came exactly 2 weeks after USPTO published the report, the non-marketing factors driving China's IP filings. And it's actually a little curious. That's last January, I believe. This January, CIPA announced, I'm going to quote the full name, Notice on Continuing and Strictly Regulating Patent Application. It's a little curious because this newly announced measure mandates that all the provincial and local IP offices, oh, sorry, let me take a step back, sorry. The last January's measure announced that by 2025, China shall eliminate all forms of subsidies. This January's announcement specifically mentioned that the reduction must be 25 per year, starting this January, towards the full elimination by 2025. It's kind of curious. I'm just thinking this could be my personal opinion. Perhaps CIPA is meeting some resistance from local and provincial IP offices, so that even though they announced last year total elimination by 2025, and the local and provincial IP offices are probably just, okay, we'll just wait. We'll wait till the last month of 2025. And the subsidies are important for numbers and to make us look good and that kind of thing. So so that's kind of interesting. So 25% per year starting now. And another, I mean, it's kind of a long measure. I'll just quickly mention a couple of things that the measure specifically prohibits. One of them is interesting, extra subsidies for large applicants, quote unquote, large applicants. I cannot remember the exact number, but if you achieve that status, let's say you have 10,000 applications filing per year, you qualify as a large applicant, you get extra subsidy per application. So the more the better. And this January, the new measure from January specifically prohibits that. It also prohibits using the number, directly using the number of applications or grants as the main condition for certain qualifications. It's kind of a welcome step towards eliminating the rigid quantitative matrices, and some other details. In the interest of time, I'm gonna skip them.
Well, thanks, Larry. And I should, before we move on, I should just mention also that China last year announced some similar measures to try to eliminate subsidies for trademark filings. However, those measures were focused on eliminating subsidies for applications as opposed to registrations. And a lot of our research, the 77 plus trademark subsidy measures that we researched in China, only 3 of those subsidy measures were based on filing application. All the rest were based on actually receiving a registration. So definitely something we'll have to continue to monitor going forward. So let's switch to IP enforcement now. David Foley. David, during one of our previous quarterly updates, one of the items you indicated that you were keeping an eye on was developments related to the anti-monopoly law. In particular, I think it was the application of the essential facilities doctrine in the Ningbo Ketian versus Hitachi Metals case. Is there anything new that you can share on this case?
Unfortunately, Mike, there's nothing we can share at this time on Hitachi Metals. As we discussed previously on November 23rd of last year, the SPC IP Tribunal heard technical expert testimony in the case. We're still waiting for some movement on the appeal. For those who hadn't joined the previous updates and aren't tracking the case, Hitachi Metals case involved the application of the essential facilities doctrine to force a patent owner to license non-standard essential patents to a competitor. So the essential facilities doctrine is encapsulated in Article 7 of the provisions of the State Administration for Industry and Commerce on prohibiting the abuse of intellectual property rights to preclude or restrict competition. That's quite a mouthful, but in 2020, SAIC, now SAMR, issued guidelines that sort of spelled out what the essential facilities doctrine meant in terms of IP cases. In the US, the essential facilities doctrine has never been recognized by the Supreme Court, and usually courts in the US recognize that in the absence of a purpose to create or maintain a monopoly, US antitrust laws don't restrict the long recognized right of a trader or manufacturer to exercise his or her own independent discretion as to parties with whom he or she will deal. So if a company doesn't want to license their IP, they aren't forced to do so as long as they aren't demonstrating a purpose to create or maintain a monopoly. Because of the potential impact of this case and the potential impact of a broader application of essential facilities, we're going to continue tracking it, and we certainly welcome input from everyone who's joining us today. If you're seeing these issues pop up, we'd love to hear from you.
Thanks, David. Are there any other developments regarding the intersection of IP and antitrust law?
Yes, so although we haven't seen any movement on Hitachi Metals, we have seen some other developments in antitrust enforcement that merit attention. On February 15th of this year, the SPC released a decision that was issued actually 2 months earlier in the AstraZeneca case. The decision addressed the potential anti-monopoly law implications of pay-for-delay arrangements in drug patent cases. This is one of the first cases in the PRC addressing pay-for-delay, and it's been widely reported on. But for those who aren't familiar, pay for delay can be broadly understood to encompass an arrangement by which a patent owner agrees to pay a potential infringer to refrain from competing against the patentee's product. What that pay encompasses can vary greatly, but oftentimes it will result in a delay in introduction of a generic drug competing with the patented drug. The facts of the case at issue here are somewhat complex, involved a number of related entities. I'm going to try to boil them down a little bit without getting too far into the weeds. But in essence, the previous owner of the patents in suit entered into a settlement agreement with another entity that challenged the validity of the patents in suit at CNIPA. As part of the settlement agreement between the two parties, the entity that was challenging the validity would withdraw its challenge at CNIPA and then would receive a license to engage in certain acts at certain dates during the life of the patent. So they were allowed to do certain things before the patent expired that other people wouldn't be allowed to do. So under this agreement, the licensing party could identify affiliates that were permitted to engage in things like declaration, registration, and production of products that practice the claims of the patents after a certain date. Patents in suit were then assigned to AstraZeneca, who then sued the defendant in the case for patent infringement. First instance court found that the accused infringer didn't infringe, although they practiced the claims, because it was determined it was an affiliate of the original settling party and complied with the terms of the earlier agreement. The decision of this first instance decision was appealed by AstraZeneca, but AstraZeneca reached a settlement agreement with the accused infringer before the appeal was heard and then sought to withdraw its appeal. And that's where the SPC comes in. Although the SPC set forth the antitrust framework for reviewing pay-for-delay arrangements, which I'll run through momentarily, the SPC didn't actually reach the substance of the agreement at issue in this case. SPC explained that because the patents in suit had expired, effectively any antitrust concerns were rendered moot, since there would be no anti-competitive effects of the agreement going forward. And the other problem was the parties that originally entered into the settlement agreement at issue weren't involved in the case, and evidence regarding motivations for the settlement, including potential strength of the invalidity arguments that were withdrawn, weren't developed, so they couldn't evaluate the impact of the arrangement. So essentially what we had is the Supreme People's Court laying out what the test is going to be, but they don't actually apply it in the case. But what the test is pretty useful in cases going forward. They made clear that when a party seeks to withdraw an appeal, the court has to review the legality of the conduct and the correctness of the first instance judgment. So legality of the conduct is where you end up with this question on Anti-Monopoly Act. So they set forth what the framework is going to be for making this determination. And they explained that determining whether a pay for delay arrangement that requires patent validity challenges be withdrawn is going to turn on whether the patent would likely have been invalidated if the challenge had continued. So some suggestions were given by the SPC on how to make this determination. They said that if the patentee gives a high amount of compensation without justifiable reasons, that can be used as an important consideration. But they also cautioned that it's generally necessary to go back and look whether the patents would have been invalidated and make a judgment call as to whether it was likely they would have been invalidated. It's not the end of the inquiry, but it's an important aspect of it. If the court determines there's a high probability invalidation would have been successful before the settlement agreement was reached, court then considers whether the agreement prolonged the market exclusivity time and substantially delayed market entry of generics. If all of those tests are met, then it's likely that there's a concern about AML, anti-monopoly law violations. So what does it mean for a patent owner? Well, when you sign a settlement agreement that requires validity challenges to be dropped, you can anticipate the court is going to analyze patent validity if that agreement is ever challenged down the road. And the chances the validity challenge would have succeeded in determining whether there's an anti-competitive arrangement is going to be considered. So we're going to continue keeping an eye on this, see how the framework is implemented in cases with facts and evidence that actually allow for review and application, as it didn't happen in this case.
Thanks, David. This is the time of the year when we see year-end reporting and typical case lists that come from the courts in China. Really briefly, is there anything that you're reading right now that may be of interest to our audience, including any reporting that may have issued from the Supreme People's Court IP Tribunal?
Yeah, so we've seen a couple of things. I'm going to touch real briefly on the Guangzhou IP Court. They released some interesting statistics. Again, we've seen growth in both number of new cases, number of cases that have concluded, a real domination of the docket by design patents, but also a smattering of other types of IP cases. The Guangzhou IP Court also released a list of typical cases for innovation protection that includes a few items worth mentioning. One of them involves the
GNU general public license violation. So the commercial use of software that's shared under the GNU source code license. Essentially, this is a free source or open source software that can be shared among software developers but cannot be commercialized. This is one of the first cases where you've actually seen somebody go out and enforce these provisions. Damages were relatively limited in the case, but it's surprising to see this being enforced. It's worth a deeper dive if somebody's interested in open source software and restrictions. Another case that was flagged in the typical cases is the Oppo v. Sysvel case. Oppo v. Sysvel is similar to the Oppo v. Sharp matter in that it involved standards essential patents and jurisdictional questions. Love to dig into this in depth, but one of the key issues on this one, something to keep an eye on, is the Chinese court indicated that it still maintained jurisdiction even though there was an earlier in time decision from earlier in time filing in a UK court. And the reason they did so is they said that allowing the UK court to have control over the case and waive their own jurisdiction might directly, substantively, and significantly eliminate or restrict Oppo's participation in the Chinese market. So therefore, the PRC court kept jurisdiction in the case. I'm going to put a pin in this issue. It's an important issue. We're going to continue tracking it, but we're starting to see more and more intersection between antitrust and IP. Lastly, I want to touch just briefly on punitive damages. We had another case in this group, the Lay Diamond Opto case. Flag it for folks' attention. It was a non-mainland China company was awarded punitive damages in a patent infringement case. This was not under the new 2021 amendments to the patent law, but under the old civil law because it predated those amendments, but it's also worth a read.
Thanks, David. That's very informative. Let's move on to Susan Anthony and trademarks and the important issue of bad faith trademarks. China has attempted to address the problem of bad faith trademark filings by making changes in its laws, regulations, and practices. In 2019, China amended its trademark law prescribing that applications made in bad faith for trademark registrations that are not intended for use must be rejected. Last year, China commenced a special campaign to crack down on bad faith trademark applications, with results to be compiled at the end of last year. So, Susan, what effect did this special campaign have on bad faith applications?
The Special Action Plan for Combating Malicious Trademark Squatting identified 10 acts targeted during the special action, including maliciously squatting on the names of public figures, well-known works, or character names with a relatively high reputation. China's State Council Information Office press conference on January 12 reported that in 2021, China cracked down on 482,000 bad faith filings and also invalidated 1,635 registered marks ex officio. There are other statistics in that report if our listeners are interested, but the takeaway here is that China often holds special campaigns to highlight its policies or its activities, and whether any particular campaign prompts a long-term change in behavior has really to be evaluated on a case-by-case basis. Here, as one could see, it's too early to tell, although the targeted acts, unfortunately, were unlikely helpful to U.S. brand owners. The press conference also reported out actions that were taken regarding the Olympics, and those were very aggressive actions, but undoubtedly this is related to the very stringent requirements of the International Olympics Committee. We didn't see any changes for other right holders, though, following the 2008 Summer Olympics in Beijing, and we do not anticipate seeing changes following the 2022 Winter Olympics.
Thanks, Susan. So China's amended trademark law addressed bad faith applications that are not intended for use. But what about those trademark applications that are intended for use or that are actually being used? Are they being addressed?
I'm afraid, Mike, that in answering or attempting to answer this question, we have more questions than we have answers. And this is part of an ongoing series of discussions that we have with CNIPA on how those particular situations are to be addressed. As an example, an applicant files a single trademark of a U.S. company not entitled to well-known trademark status, which is almost all of us. The well-known trademark status is even difficult for the Cokes and Pepsis of the world. So the applicant files a single trademark of a U.S. company intending to use the trademark to sell similar products and trade off the goodwill of the U.S. company. Covered or not covered? We don't know how that's going to be addressed. Similarly, we don't know in opposition and cancellation proceedings, how can a trademark owner contest the trademark application in an opposition or cancel the trademark registration of a bad faith filer who actually uses or intends to use the mark. And an example here would be a counterfeiter who files the trademark of a legitimate brand owner to sell fake goods in China, to export fake goods outside China, or to avoid takedown of fake goods by e-commerce platforms. So as you can see, more questions than answers, I'm afraid.
Thanks, Susan, and something definitely to monitor, as this is one of those problems that affects almost all of our companies that are doing business in or with China. So hopefully we'll have some favorable developments at our next quarterly update. So let's go on to trade secrets of Mike Deal. Mike, I think you've been reviewing the white paper for 2021 that the IP Court of the Supreme People's Court issued a few weeks ago, with a particular focus on trade secret cases. What did you find in the report? Mike, you're mute.
Thanks, Mike. It might be more effective if I was off mute. So I want to review the white paper that you mentioned, but I also want to look at, and I should have mentioned this, some summaries that the same court issued. This is sort of like, these big cases or important cases. So the white paper and the summaries came out in late February, and there were about developments in 2021. There's kind of two things we can take from that. We can look at the statistics and try to get a sense of, are more parties using China's civil system to try to address thefts or misappropriations of technical secrets? That's one issue. And the other is, we get a sense of what does the court want to highlight about its own jurisprudence, because we get a very selective presentation. So let's take a look at that. So first, let's just remember what the jurisdiction of this court is. So it was created in 2019. It was made part of the Supreme People's Court. It has the jurisdiction to hear appeals of patent cases and other what they call complex intellectual property cases and anti-monopoly law cases. So it's not all IP cases. That's important to keep in mind. And because it only has jurisdiction over the technical cases, it means that it does have jurisdiction over appeals of what China would call technical secret cases, but not commercial secret cases. So that what we would call trade secrets, which could be either one, China divides in half. And this court's only going to hear those technical secret cases, unless there's something complex about it or an anti-monopoly law claim is included. All right, so trying to get a handle on whether parties are using the civil system more. So we look at the statistics, and we see that this court heard roughly 2,500 appeals of patent or other complex cases in 2021. And of the 2,500, only 79 were on technical secrets. So that's a very low percentage, but it's actually a high number compared to the year before. So there's 79 of these technical secret appeals in 2021. The year before, it was only 44. So if that trend line were to keep going up, we might be able to say that it's a favorable indication that more parties think it's worth it to pursue civil redress when they have the theft of a technical secret. Now, the white paper, besides giving numbers, it gives sort of a narrative description of some of the issues that come up in these technical secret cases. And they say the issues that come up most commonly are disputes as to jurisdiction, about what is the proper definition of the asserted technical secret, and then what Chinese law calls confidentiality measures, and that means whether the trade secret holder has taken enough actions and been diligent enough to keep the secret, actually keep the information secret. There are also appeals over what does it mean to the case if there was a modification or an improvement to the trade secret, and also appeals about proper damages. All right, so that's the white paper that I mentioned. I also mentioned that there are these summaries that they issued on the same day. So these go to 48 out of out of thousands of cases. So there's only very few are summarized. As to the 79 technical secret cases, we only see 6 or 7 summaries. So it's interesting because we get to see what the court wanted to highlight publicly about what it's doing. I picked the 3 that I thought were most interesting, so I'll go into those. So in one of the cases, the court highlighted that there were different kinds of trade secrets involved in a single case. So this one involved computer software source code. It involved algorithms and what's translating as logical relations, yet a third kind of sort of technical secret. And what the court emphasized is that the trade secret holder, the plaintiff in the case, was going to have to establish that each category qualified for trade secret treatment. And so you have the court sort of wanting to show the public that it is going to hold, and that lower courts should also hold the plaintiff's feet to the fire in terms of establishing trade secret eligibility as each kind of trade secret. So that's interesting. The second one is it stated that the expiration of a party's contractual obligation to protect a trade secret, to refrain from disclosing it, that just because that has expired does not excuse the party from other obligations that it might arise under different sources of law to keep the information secret. So in particular, this summary, and again, we're only working with these short summaries, it mentions that obligations arising in tort law or what they called post-contractual confidentiality obligations arising under the principle of good faith. So in other words, that contract might have ended, but other sources of law are still ongoing. That's actually welcome to see. In late 2020, the Supreme Court People's Court issued a judicial interpretation indicating that even when the confidentiality obligations are not stipulated in a contract, the court may find that they arise under other sources of law, including the principle of good faith. So it seems to be a case that came close to exemplifying this measure. And then I'll go to the last summary that I wanted to highlight. Here, the court set out that the plaintiff had provided evidence to show that the alleged infringer had illegally obtained the entirety of the product process. Also that the defendant had complete sets of production equipment and other technical secret information. Also that the defendant was making the same product as the plaintiff, which these procedures pertain to the manufacture of. And so what, according to this summary, a presumption arose that the defendant had used the entire technical secret based on a preponderance of the evidence. And this reminds us of Article 32 of the Anti-Unfair Competition Law, which provides that if the trade secret holder can provide prima facie evidence of infringement and access to the trade secret, then the burden shifts to the defendant to establish non-infringement. It's not a perfect parallel between what Article 32 says and what the case says, but it's sort of in the ballpark. So Mike, you asked, what we found here, stepping back from the specifics, we have some data that suggests maybe there's an uptick in the use of the civil system to address technical secret misappropriations. And we're getting some interesting indications of what the court wanted to present to the public as the kind of issues that are coming up.
Yeah, and this is the type of information that is necessary, I think, for rights holders to understand how best to protect and enforce their trade secrets rights in China. So it's very useful and helpful to get this information, albeit fairly limited. I would imagine you didn't, there wasn't reporting on specifically how many of those cases, the 79, were involved foreign parties.
Oh, right. I'm glad you raised that. The white paper does say the overall percentage of its appeals that are foreign related, but it doesn't break that down by type of IP. So the overall number is 9%, but we don't know what percentage of the technical secrets cases were.
Right. Okay. Well, thank you very much for that report, Mike. I want to just remind the audience too that you can have an opportunity to ask questions. Again, you submit your questions by email to askchinaip@uspto.gov. We will, though, continue until we get those questions. Any questions coming in, we'll continue with our discussion and maybe go back to Neil and talk about the important issue of sports broadcasts. Copyright protection for live sports broadcasts has been an ongoing concern for U.S. companies and a longstanding issue in discussions between IP officials in the United States and China. This was an issue that was extensively discussed over a period of years in the U.S.-China Joint Commission on Commerce and Trade, what's referred to as JCCT. And the last JCCT fact sheet in 2016, before the JCCT was discontinued, specifically mentions the topic. Neil, can you give us a brief update on where things stand with this issue? Has their approach to this issue changed over the past several years? And did the recently concluded Beijing Olympics reveal anything about China's current position on this issue? You're muted, Neil.
Happens to everyone at some point. Thank you, Mike, for your question. For many years, China's copyright law did not provide clear protection for live sports broadcasts. Chinese courts cited two primary objections to such protection. First, that the broadcast of a live sports event program did not contain sufficient originality to qualify as a copyrightable work. And second, that purely live broadcasts could not be protected because they were not fixed or recorded. The lack of clarity was starkly illustrated during the 2008 Beijing Olympics. To ensure that Olympic game broadcast at that time would not be retransmitted by pirate websites, China's Copyright Office, which we call NCAC, adopted a set of sui generis regulations to provide a separate non-copyright basis for combating online piracy. So the fact that NCAC concluded that sui generis protection was necessary was a clear indication that NCAC viewed copyright protection as uncertain. As you point out, Mike, the issue was discussed in the JCCT during the period 2009 to 2016 and at more senior levels, and was even considered a candidate for the Phase 1 agreement at one point. The situation for U.S. right holders reached its nadir in many ways in 2018 when the Beijing IP Court decided two cases. In both, the court held that sports broadcasts could not be protected under the copyright law because they displayed insufficient originality and lack of fixation. Since then, however, there have been at least two positive developments. First, in 2020, the Beijing IP Court, just out of the blue, totally unexpected, it reversed its two earlier judgments from 2018. Second, in November of 2020, China's National People's Congress passed copyright law amendments, and those amendments included several changes to address copyright protection for sports broadcasts. These developments appear to have affected a change in policy at NCAC. One indication of this change is that during the most recent Olympics this year, NCAC did not issue the sui generis regulations to protect live sports broadcasts. This suggests that NCAC now takes the position that the current copyright law can protect those broadcasts and that sui generis protection is no longer needed. NCA's conduct here reminds me of the famous Sherlock Holmes story about the dog that didn't bark. The fact that the dog didn't bark was a key piece of evidence used to identify the suspect, and in this case, NCAC didn't issue the sui generis regulation, and I think that's a positive sign. It's also, I think, a good example of how persistent U.S. government advocacy over a period of years can eventually bring about a change in China's IP policy. We'll be monitoring Chinese court cases under the new copyright law to see whether the issue has finally been resolved.
Thanks, Neil. That is a positive development. Let's turn to another hot topic, and that is patent linkage and patent term extension. Larry, biopharma innovators are very interested in developments in China's system for past patent linkage and patent term extension. Can you give us a quick update on where things stand?
Sure, Mike. So as we probably all know, the patent linkage, the patent law, and a number of measures on patent linkage have all been finalized, and a large number of cases actually have been filed. Last time I read, it's like over 1,000 cases have been filed. Most of these cases are going through the proceedings. I have not heard any cases reaching the decision yet. So we're certainly everybody's paying very close attention. I want to point out the cases. There's this dual track system. China's linkage system is a little different from the US in the sense that you can file either at Beijing IP Court seeking the judicial adjudication, or at CIPA seeking administrative enforcement. Turning to the, actually, let me just mention, quickly mention what David mentioned, the reverse payment issue. It's tightly related here because the settlement issue that David mentioned all comes out from the patent linkage cases, the patentee suing a generic or biosimilar applicant for patent infringement. When you settle, I want to echo David for the importance of keep close attention on that SPC case and further development, because otherwise your settlement could be violating anti-monopoly law in China, incurring I'm not sure actually the exact consequence, but that's certainly not pleasant for the patentee and the party and the generic applicant trying to settle and then triggering an antitrust violation. And I want to also point out it's actually a fascinating issue. I don't have any answer in my mind. I invite audience, if you have any insights or something, perhaps you can comment through the Ask China IP USPTO email. The antitrust issue logically applies either at Beijing IP Court, it goes through the judicial route, or CIPA, seeking administrative enforcement, because logically the settlement, they're the same. Substantively, the cases are the same. So how does the antitrust issue being handled if you go through the administrative route? I don't think CIPA has jurisdiction determining antitrust issues, but the issue is logically there. I don't know what's going to happen. It's kind of an interesting question. And the other important topic, as you mentioned, Mike, the patent term extension, which is the patent office compensating a patentee because of regulatory delays. I got my patent, but just simply because it's going through in the US, it's going to be FDA, in China, NMPA regulatory approval, I cannot sell my products. The patent term extension compensates you for that. But we have learned from rights holder, however, China is contemplating defining a new drug as new to the world instead of new to China. So in other words, if a company market its drug launch its drug first in the US or in Europe, then later launching in China, you're asking CIPA for patent term extension, you're out of luck because, hey, your drug was launched in Europe last year. Your drug is no longer new, even though China is still doing regulatory review, even though it's new to China, it's not new to the world. Therefore, no patent term extension for you. And that is different from any jurisdiction in the world, as far as I know. So that's a huge concern because, as you can imagine, most of the multinational pharmaceutical companies launch their products outside of China.
Thanks, Larry. You mentioned over 1,000 patent linkage cases currently. As these cases go through the administrative and judicial processes in China, what should the parties in these cases expect and what should they pay attention to?
Yeah, that's I can think of number one is the issue that I mentioned, the antitrust issue. Number two, I believe rights holder giving them the choice, they would want to go through Beijing IP Court, giving their expertise on patent infringement and their technical expertise. But because the China's patent linkage have a very short 9-month stay, the 9-month stay means the NMPA can stay their regulatory approval, wait for the infringement dispute to play out. The rights holders are kind of forced to file at a CNIPA, hoping that CNIPA action typically faster than judicial action. But you're kind of forced to choose to go through a tribunal that normally you would not choose to adjudicate a patent infringement case. So I guess the short way of saying that would be, I mean, including myself, I think the everybody going to be closely watching how well CIPA can adjudicate these cases. Can they do as good a job as Beijing IP Court?
Thanks, Larry. And it looks like someone's asking for the link to the SBC IP Court's white paper, and we're trying to post that to the in the chat for you. Let's go on to David. Back to David on IP enforcement. David, in August of 2021, the Supreme People's Court issued a draft interpretation on several issues concerning the application of China's anti-unfair competition law. The SPC just issued the final version of this interpretation. Is there anything that caught your eye in the final measure?
Yes, Mike, thanks for bringing that up, actually. As background, the judicial interpretation addresses a number of issues for civil disputes arising under the anti-unfair competition law, including claims based in trademark as well as trade secret claims. As a lot of folks are aware, Article 2 of the AUCL has been a key tool to combat bad faith trademarks and the actions of those who hold bad faith trademarks. Some of the language in the original draft issued in August might have been interpreted to limit the ability to utilize Article 2 of the AUCL for that purpose. However, that language has now been softened in the final version, including some pretty significant changes to Article 1 of the judicial interpretation. We're going to keep an eye on this issue, but we're hopeful that Article 2 of the AUCL will continue to remain a tool for combating bad faith trademarks and those who engage in bad acts using trademarks obtained in bad faith. There's a couple of additional clarifications that were provided in the final version when compared to the original draft, including who bears the burden of proof on setting forth evidence of what business ethics apply to a particular industry. Also, who or where does infringement occur in the e-commerce space, which was clarified that the location of delivery can't provide a basis for establishing jurisdiction. So just because you specify a particular location for a infringing good to be delivered does not mean that the court in that location has jurisdiction. We also noted a new Article 27 was added to the final version of the judicial interpretation, which appears to have general applicability for extraterritorial jurisdiction for all acts of unfair competition.
Do you see any, do you have any thoughts on what that new Article 27 may mean in practice?
And it's not entirely clear just looking at it, but on the whole, Article 27 provides that where an accused act of unfair competition occurs outside of the territory of the PRC, but the result of the infringement occurs within the territory of the PRC. If a party asks for jurisdiction at a court in the PRC, then the court will honor that request. It's not possible to know exactly what Article 27 is intended to cover, but one possibility is that the purpose is to provide extraterritorial reach of the AUCL akin to the reach of the Defending Trade Secrets Act that exists in the United States. So under the DTSA in the US, when a trade secret theft occurs outside of the US, but the defendant uses that trade secret within the US by advertising, by promoting, marketing, selling goods in the US that embody the trade secrets, there's a sufficient tie to the United States for the court to reach the underlying theft that happened outside of the US under the DTSA. Now, We don't know what it's going to mean in practice. It's possible this was the intent. So we're going to continue to keep an eye on it as cases come in, as cases are filed under this new judicial interpretation to see if this is the way it plays out for extraterritoriality.
Thanks, David. It looks like we're right at the top of the hour. I don't see any other questions in the email box. If others have questions, attendees, after they can send those to us. We'll make sure that we try to address those even after the webinar is over. Just want to thank our panelists again for the fine job that they did in providing developments for us today. Also appreciate all who attended this program and encourage you to fill out the survey when you receive it. Also be on the lookout for our upcoming webinars and hope to see you on our next updates webinar on in June of this year. Thank you, everyone.